talked a lot about risk today and how to take it and why it's a good reason to take it. It's a good reason for your business. I'm a lawyer. I hate risk. So we are going to be talking about issue spotting risk. My goal here is for you to look at things that are happening within your business and be able to say, is this a risk I'm willing to take? If the answer is no, or I need more advice, pick up the phone, call your lawyer. So this is what we're going to talk about. We're going to talk about these 6 things. It doesn't have to be 6. It could be 5, 4. But I think these are the areas where if you ignore the issues here, you could be putting your business in a situation that you really just don't want to be. So let's start with patents and trade secrets. You know you have something. You know, what is it? You know, everybody's excited about the it in your game. Can you do anything with it? Can you create a valuable intellectual property portfolio? The reason why you should be thinking about this is because it's one of many different exit strategies your business might have. It might be to have a valuable IP portfolio that you sell. Some of you may have heard of the Alice case. You know, in common nomenclature, it is the death knell for software patents. I'm here to tell you that it's not. You can patent video game software. So there's 2 recent examples of software patents in the video game space that have survived challenges in court, that have been used in court. And so the point being, if you've heard you can't patent what you have, the answer is you might be able to. And so you really should be thinking about, if I have something, if you have something you're excited about, can you patent it? The other side of the patent coin is trade secrets, right? Patents are public. You make the information available to the population. Trade secrets are exactly the opposite. They're valuable because no one knows about them. The Coke formula is the example of a trade secret. A trade secret doesn't exist just because something is secret. A password on a computer and an agreement with your employees to keep everything confidential is not nearly good enough to create a trade secret. So the list here, you know, it's not for you to remember. The concept is there are a lot of different things that you need to think about whether or not you are indeed creating a trade secret, if that's something that you have. If your company is going through some sort of due diligence and you're able to show we have these 3 patents, we have these 5 trade secrets, here's how we protected it, that IP portfolio has a lot of value. So if you think you have something that's valuable, think about your trade secrets and think about whether or not you should really dig into the various ways in which you're protecting the secrecy of that information. You should also be thinking about best practices in the trade secret space. And there are 2 issues there. One is protecting your own trade secrets, making sure that your trade secrets aren't leaving the building, right? The other is making sure that you aren't ingesting someone else's trade secrets, because that's when you see litigation. That's when you get sued because you hired someone and they brought with them documents that they weren't supposed to bring. Or they didn't bring them into your company at all. They kept them on their computer at home. But if you're not talking to onboarding employees about the agreements they have and making sure that they've deleted all of that data, you may be setting yourself up for a lawsuit. So in the IP portfolio space, if you think you have valuable information, think about your patents and think about your trade secrets, and don't ingest someone else's trade secrets into your business. Copyrights, really quick. If at ever any moment you think, I've seen this before, I've heard this before, I get this, I've played this game before, stop. Hit pause, pick up the phone, call the lawyer. Because copying and copyright infringement, it doesn't have to be identical. An homage to something can be enough to get you into the situation where you're dealing with copyright infringement issues. The 2 games that are on the screen here come from a litigation in court in San Francisco. The game on the left sued the game on the right over various elements about the game that were alleged to have been copied and were copyright infringement. You can see it's not the same game. You can also see that there are similar elements. So if at any point in time there's anything that you think, I've seen this, pause. Litigation over tattoos, litigation over images. So really just tread carefully if you ever think that you might have something in your game that someone else had in their own IP. Contracts. I get it. Lawyers are expensive. And one way that I see businesses cut corners is they hire the CFO to write the contract, or the president writes the contract. We're not going to hire the lawyers to write the contracts. Perhaps the most ridiculous situation I saw was two guys with one laptop and the internet, and they found contractual provisions that they liked, and they mushed together a document. And then someone doesn't pay someone, and now we're into a lawsuit, and who knows what this contract means, because the contract wasn't drafted for them. You know, it was terms that were drafted by somebody else that they pulled off of the internet. Don't do it. It's incredibly expensive to deal with litigation. So, you know, pay the couple $1,000s to work with a lawyer to have a well-drafted contract, because that will not only protect your company. If you are thinking about an acquisition strategy, the lawyers for the company that's acquiring your business will be looking at the contracts and will be making decisions about whether or not your business is one to do a deal with based upon the quality of those agreements. If they think there's a problem, you either might not get acquired, or the price might not be right, or you might have some provisions you have to give back. So just don't do it. Terms of use. Most games have terms of use embedded inside of them and a privacy policy. They should. They're also probably, for the most part, unenforceable. Why? Because most studios aren't thinking about creating an enforceable term of use from the perspective of contract law. That's how the courts think about terms of use. Do you have a contract with your player over the language that's in the terms of use? And let's really get down to it. You probably have a class action waiver in there. You know, that 1,000 people can't sue you. You probably have an agreement to arbitrate in there. Courts don't enforce those if you don't create a mechanic where you can prove you had a deal with the player over the terms of use. So that I'm not picking on someone else's game. We've created our own pretend game, Foxy's Big Day. So let's see how we would create an enforceable term of use in Foxy. The very first screen when the player loads the game should be the user agreement and the privacy policy. And before any gameplay happens, that's a best practice. That's my preferred approach. There are some problems with this screen. The first is you need consent to the privacy policy too. Your privacy policy is also a contract with your player. So use contractual language. By selecting agree, you agree to the user agreement and the privacy policy. Great. Now show your user a link to get to the user agreement, a link to get to the privacy policy. You don't need the don't agree button here. If they don't click agree, they don't move forward. The screen on the right, this is my preferred approach. I think this is a gold standard, if you will, which is that you list up front all of the agreements. We've added a third, an end user license agreement. Certain games have 4 or 5 different agreements, depending upon how you break it out. Whatever it is you think your user needs to know to play the game, you need to get consent to it. So list them out, make sure that they can see it, and then use language of consent. I have read and accept the privacy and cookie policy, terms of service, and end user license, and accept. Language of consent. A court will enforce this. Here's one a court won't enforce. I've seen this, it's terrible, don't do it. So we have a scroll bar, if you will. Maybe you're telling a story about Foxy's gonna go find her friends and it'll be great and you should play the game. And you can hit play now. You don't have to read the story. Okay, but if you were, you get all the way to the bottom and you see by clicking play, you agree to Foxy's user agreement and privacy policy. You never had to scroll down, so the court will not enforce it. If you can't prove that the player absolutely necessarily had to see the agreements that you wanted them to consent to, that they understood that by moving forward they were consenting, it will not be enforced. So you could have a class action, you could have arbitration issues, you could have the FTC talking to you about how you're using data because you didn't get consent over the use of data. So here's a, not best practice, but another approach to getting consent to user agreements and privacy policies, which is to host it up in the middle of the game at some point. Perhaps it's right before the player purchases a token or creates an account, or it's at the end of the tutorial. Whenever it happens, that should be a conversation you have with counsel. So if you're gonna go this route, you should be talking to a lawyer about when is the best time to serve up the consent agreement. If you do it though, don't hide it. Don't be coy about it. Don't be cute. Don't try and like keep the player going and get the agree. Make it big, make it bold, make it clear, and use, again, language of consent. I've included a don't agree button here. You don't need it. If you had it, the game would shut down, right? If someone doesn't agree, you don't let them continue. Privacy, we're gonna talk a little bit more about privacy. Games are global, mobile games in particular. We're in the US and we're very US focused. If most of your players are in the US, there may be a reason to have a privacy focus that's very US focused. If most of your players or most of your money or a fair percentage of it is coming from outside of the US, you need to think globally about privacy because the United States does not have the most stringent laws as it comes to data privacy. That would be Germany, the EU, Canada, Australia. So do the most for the most people. I'm not asking you to have 190 different privacy policies that comply with all of the laws of all of the various different countries. You might have two. It might be the US and everywhere else. It might be Korea and Germany and everywhere else. That's a conversation to have looking at the numbers and looking at the data that you know about. So if you're not 100% US, you should be talking with a lawyer about how to keep the most people happy so that you don't fall into problems outside of the US. In the US, if your game is targeting children, think about whether or not you can satisfy the most gamers on your platform, the kids and the adults, whether or not you can segregate some section of your game that perhaps isn't appropriate for children. I'm a parent. I think of the chat functions in some games that really are appealing to my children, to my under 13-year-old children, and some of the language in the chat is not appropriate for them. A better practice would be to age-gate that game so that if the user is under 13, they don't see that chat function. They're not talking to someone from a different country. If you're going to use an age-gate, for whatever reason, yes, no is not a practice I like because I can tell you my 5-year-old can figure out which button to push so he can keep playing the game. I prefer the option on the left here, and the reason why is I don't think he can figure out how to put in the right date to trick the system to get over 13. If for whatever reason you see behavior that suggests that you have a child trying to figure out the system, you understand your data, you should really be thinking about how do I demonstrate to the parties that matter, and the parties that matter are plaintiffs who are suing you or the FTC who's really worried about how you're using data, that you've really tried to segregate out children. So think about an age gate if it's appropriate for your game and who your audience is, and you know that information best. Privacy policies we've talked about, those are contracts. If you change them, you need consent again. The change is not enforceable, will not be enforced if you don't get consent again. So if you update the privacy policy, so Foxy's updated her privacy policy, the very first thing the player should see is a notification. We've updated the privacy policy. Check it out. The check it out would be a hyperlink to the privacy policy. You could be a little bit more specific if you wanted to be. You could say this is what we've done. Now we're tracking your location data. But whatever you do, remember, it's a contract. And so use language of consent. I agree, I accept, okay, continue, not good enough. The last topic that we're going to talk about is direct marketing. And so I mean two things. I mean email marketing and I mean text marketing. You don't need to worry about the language that's on either one of those slides. And I'll tell you why. There are a lot of statutes that regulate text marketing, email marketing, how you can do it, the best ways to do it. It's complicated. It's very heavily regulated. There's a lot of lawsuits over it. How might you do it? You might be sending emails to your players that says, gee, it's been 10 days since you were here. We're going to give you something. We're going to give you a token. We're going to give you, whatever, a widget in the game. It might be, hey, send this email to 5 friends and we'll give you the token or the widget or the whatever. Any of that kind of behavior to drive attention to your game is risky, and you should absolutely 100% be talking to lawyers about how to make that system work so that you can satisfy all of the various things that you need to do in order to satisfy the statutes. And then a bonus, since we have a little bit of time on the clock, which would be, we've heard about it earlier, influencers. If you're going to use influencers, right, the FTC is paying a lot of attention to that these days. You should be thinking about what your disclosures look like. You know, the note there is you need to disclose that you're paying people to promote your game. So 6 takeaways. If there's something cool about your game, something really exciting about it, you might have an invention that's patentable, you might have a valuable trade secret, you can create a lot of value for your business if you think about it up front early on and whether or not you want to take the steps to protect it. Also, by creating that IP, you can create a buffer between your business and others if there was ever to be any sort of litigation. If you're taking inspiration from anything, you know, be it songs, movies, art, tattoos, other games, hit pause, you know, because you don't want to find yourself in a copyright infringement lawsuit. You could certainly take steps to insulate yourself by getting clearance, by going to the artist in the local gallery and saying, hey, I'll pay you $100 if I can have the right to use that art in my game. Early on, they'll probably say yes. If your game has, you know, 5 million users and is making a ton of money, it's not going to go for $100. Don't find your contract terms online. Just don't do it. Your terms of use and privacy policies, they're contracts. Think about them like contracts. Make steps within the game to make sure that you're getting consent to both of those things. And have a global approach to privacy. You know, we're in the US and we think about our laws, but the global approach is really important to make sure that you don't find yourself dealing with a regulatory action in Germany. And then if you're going to drive traffic to your game with emails and texts, it's risky. And so just stop right there. You can do it, but you need to talk to a lawyer first. Questions?
Thank you very much. Yeah. I mean, I've got a quick question. One of the things that I think was interesting there is that, as you rightly say, we have to be really upfront when we want to have terms like privacy policy and terms of use. But I think I wonder if there's a kind of tension between the onboarding process and that sign-up process. Because we know that if you have registration really early on, kills your adoption. Mm-hmm. How have you helped people kind of understand how to balance that judgment call?
So my general rule of thumb is if you're not collecting any data, you're not collecting any money, you're not collecting any email addresses, you're just giving the user a tutorial, that's a reasonable risk. So go ahead, teach them how to play the game, get them interested, get them excited, and then use a very clear, big, bold process where they have to consent to continue. If at any point in time in the tutorial, though, they can give you an email address, any sort of personally identifying information by creating an account, or they can start buying tokens, at that point, you need to have consent, because the question is, did they understand what you were going to do with the data? Did they understand what you were going to do with the money? Did they understand that? If they don't, and they come back and sue you, right?
I think that really is the key. Generally, it's about consensus being built, rather than trying. You know, we don't want people to feel that we tricked them into a process. We want to be transparent. And what I found really interesting in my career, and I've worked on all sorts of bases like PlayStation Home and mobile operations, various things like that, is the more transparent you are, the more people trust you.
Yep.
And the more people will spend money.
And that's why you shouldn't hide it. Be big, be clear, let them know what you're doing, and they'll click through and keep going.
Exactly. Does anyone else have a quick question? We can probably get one in. There's a question over here. We've got a microphone just coming to you.
Thank you. Excellent talk. I was wondering, when you localize it for other countries, should you translate the terms of service and privacy policy into the native tongue?
It depends upon your jurisdiction. So in Germany, you must. Right? So you don't have a choice in Germany. I'm not a German lawyer, so I can't speak to all of the German laws, but having done it, I can tell you, you must translate into German. If you were going to go into Korea or Japan, you would do that there as well. They have different laws. For the most part, you see the approach, the general approach is US and everywhere else. And then in Germany, you would serve it up in German, and in Korea, you might serve it up in Korean, and Japan, etc. But you're not necessarily going to translate it into all languages that are out there, and you're really thinking about what's your data, because that's where your risk is, right? If 90% of your users are in Germany, you should be paying a lot of attention to German privacy laws. If you have 2 users in Germany, yeah, maybe you don't pay for it, you know? Technically you're supposed to, but maybe you don't pay for it because you've only got 2 people there. So you really do need to be paying attention to, you know, players or revenue. I think more in terms of players, but revenue would be another way to sort of slice and dice that.